your story about starting on time and finishing on time one way. My friend and longtime co-author, Marcel Cahan, invited me to the bat mitzvah of his daughter. And I asked her, what time do we know to start? And he said, you're asking the wrong question. The right question is, when do they end? But it's great fun to be here. I've been here for about a month. Kobe and I had great fun teaching a comparative Delaware-Israel corporate law course, where we took paired cases, one case from Delaware, one case from Israel, and taught them in parallel the way of doing corporate law. So we did MFW, and we did Osama Small. And it was a fascinating experience to do it, because you could immediately see all of the questions that come up in trying to transplant or even be influenced by corporate law decisions from one jurisdiction in a different jurisdiction that has a different structure, a different statute. And so it's really a great opportunity to come talk to you a little bit about what we're doing in the restatement of the law of corporate governance that got started about 2 years ago. And that is going to last for at least another 10 years if we get it done quickly. So let me start with the basics, because the restatement is a funny kind of project and document. It's the production of the American Law Institute. The American Law Institute is the premier law reform organization in the United States. It's a combination of lawyers, judges, and academics. There are about 4,000 members. And every prominent judge in the United States essentially is a member. It does three sorts of projects. It does restatements, it does principles projects, and it does model laws. So the Model Penal Code is a product of the American Law Institute, and it's been adopted by many states. Principles are somewhere between proposed statutes and good advice. But the core project that the American Law Institute has done for almost 100 years are restatements. And so there's a law of the restatement of law of contracts, of torts, of property. And it started because the United States, of course, there are 50 states, which means that there are 50 different laws of contracts, there are 50 different laws of torts, 50 different laws of property in every other area. And so as an attempt to harmonize, to improve the law starting in common law subjects, they created this thing called a restatement. And it's an attempt, when you look at it in the beginning part of what we circulated, and you'll see the official statement, it's an attempt to recapitulate the law as it presently exists, but not just to do that. It reminds me a little bit of, the old Yiddish translations of Shakespeare usually said "mitvargam u'mishupar," right? So exactly. So it's a bit of that. It's to restate the law in its best form, taking into account developments in the law, looking at the arc of the law. So there's a great deal of judgment in what one ends up writing down. The institutional process is as important as the content. So there's a reporter, which is the head of the project, and that's me. There are two associate reporters, my old friend and colleague at Penn, Joe Fish, and my old friend and colleague at NYU, Marcel Cahan. There's then a key group of advisors. And I'll take you through some of the list. It's really a wonderful list. It's a combination of everybody you would want to have in the room working on a project like this. It then has to go, the drafts that we draft and run by the advisors then goes to the ALI Council, which is the board of directors of the American Law Institute, who have to approve it. And if the council approves it with changes, it then goes to the membership of the ALI, and it's then debated at the membership. And it went to the membership for the first time this May. Fortunately, or maybe unfortunately, fortunately we were after the debate on the Code of Student Sexual Conduct, which, as you can imagine, was extraordinarily controversial. So by the time it got to the tentative draft number 1 of the Principles of Corporate Governance, I think people were a little tired of arguing, so it went through quite smoothly. And in this first block of material, we cover some of the key questions. We cover the objective of a corporation, the duty of care, the business judgment rule, the general statement of the duty of loyalty, and related party transactions involving a director or officer, as well as related party transactions involving a controller and the definitions associated with that. The structure has been constant from the beginning of the restatements. There is a black letter law section, which is an attempt to restate the law. There are then comments, which are quite extensive. The black letter law section and the comments are official pronouncements of the American Law Institute, and they have to be approved by both the council and the membership. And then there are reporters' notes, which are the province of the reporters, which are a wonderful research source, a headache to prepare, but lots and lots in there. So let me turn now to the document itself. And I'm going to stand here because I'm going to have to. So this is what it looks like. I want to first take you to that's the council, which is an eminent group. But I want to take you first to the advisors. It's a good example of who's involved. And in putting this together, we had a variety of ambitions. One was to make sure that we had people who were widely respected so that when we finished it, the thing would be accepted. So one of the questions was, and it sort of was a dream assignment for somebody in this field. So if we wanted Silicon Valley to buy into it, who do you want to have on a project from Silicon Valley? You want Larry Sonsini, because there's no lawyer in Silicon Valley as respected as Larry Sonsini and Wilson Sonsini. So I called up Larry Sonsini and said, will you be an advisor? He said yes. And with respect to the lawyers involved, we sort of started with folks like Larry Sonsini. So Larry's involved, and Marty Lipton is involved, and Ron Olson and Bob Denham from Munger, Tolles and Olson are involved. Raj Cohen from Sullivan and Cromwell, and so forth. Not, in some cases they're doing a lot of work, so part of the value of having them as advisors is when I call them up and ask them questions, or to do something like find out what industry practice is, they're available to do that, and they've been incredibly helpful in doing that. The second big group of lawyers are the litigators, and so we have leading litigators who both are on the shareholder side, like Randy Barron and Joel Friedlander and Mark Lebovich, as well as leading litigators on the defense side, like David Berger and Bill Savitt and from Wachtell Lipton, as well as a whole slew. Among the academics, it's more or less the folks you might think. It's quite a small group, so we couldn't include everybody because the total group is limited. So Lucian Bebchuk, Jeff Gordon, and Ron Gilson, and so forth. Among the judges were quite an interesting and hard group to do, because on the one hand, we absolutely wanted to have the then sitting Chief Justice Leo Strine, but we also didn't want to have only the then sitting Chief Justice Leo Strine, because he has strong views. So we also had his immediate predecessor, Myron Steele, who disagrees with Leo Strine on almost everything, so that the view of one Chief Justice would not be determinative. There would always be another Chief Justice to disagree. Similarly, from Chancery, we had the then sitting Chancellor, Andy Bouchard. We have the current sitting Chancellor, Kathleen McCormick, as well as important judges from outside of Delaware, like Frank Easterby. So it's, again, on the judges, and it's this incredible group that actually pays close attention to what we're doing, gives us detailed comments. We've got a group of general counsel of major corporations. We have the general counsel of BlackRock, the general counsel of Vanguard, the former general counsel of Goldman Sachs. On the finance side, on the industrial side, we have the general counsel of 3M, and general counsel United Technology. So the idea is to put together a group that can both provide substantive input as well as provide credibility to the outside world. But let me now turn to some of the key sections. So the first section that has created a lot of controversy is the question of the objective of a corporation. And as you know, this question of corporate purpose and for whom is the corporation managed has been a matter of huge public debate in the US, in Europe, I think to a lesser degree here. And one of the challenges here was what to say, how to define the task of restating the objective of a corporation. One idea that was suggested is we should take a position on for whom a corporation should be managed, and to take a position on the question of corporate purpose, question of stakeholders, whether the corporation should be managed just for the benefit of the shareholders or should be managed for the benefit of all of the stakeholders. My view, the view that we ended up following, is that that was an impossible task to undertake because there was no way that we could get consensus or anything close to consensus on that. So instead we took a different approach. We decided to view this as a descriptive exercise of the enterprise form that we call the for-profit corporation. And there, the challenge was that it exists in different forms in different states. And the big divide in the United States is between the traditional common law jurisdictions like Delaware and the so-called constituency or stakeholder states that rejected Delaware's approach to the sale of company situation in the 1980s, the Revlon doctrine, and instead adopted statutes known as constituency statutes that make it clear that the board has discretion to consider the interests of a variety of different constituencies. In the end, we decided to restate both of them because there clearly are these different approaches with some degree of difference in outcome, which was in the comments. If you take a look, you'll see that we've addressed it in various places. So the first part here is simply, I think, an accurate restatement of the traditional view, which is that the objective of a corporation is to enhance the economic value of the corporation. Enhance, not maximize. I don't think the law in the United States requires that the economic value be maximized, but that it is, I think, an accurate description that the objective is to enhance the economic value of the corporation, but it has to, of course, be within the boundaries of law. And both of these apply both to the common law jurisdictions and to the stakeholder jurisdictions. Where they differ is with respect to 2.01a. One, that in common law jurisdictions, it's for the benefit of the corporation's shareholders. And then we added the second sentence, in doing so, a corporation may consider, and we list a variety of different considerations. One of the Delaware judges reviewing this said to me that the four most important words here were in doing so and may, because it doesn't derogate from the shareholder primacy, if you will. It says that in promoting and enhancing the economic value for the benefit of the corporation's shareholders, the corporation may consider these factors, not must. And one of the fights, as it were, with the advisors, in particular Marty Lipton very much wanted us to restate a stakeholder vision of the corporation. And his first push was to make this not may, but must. A second approach was to end it right here and not say anything about it, which his view was implicitly would include a stakeholder view. In the end, we put in a stakeholder view, but we put it in the second part. That in stakeholder jurisdictions, it's for the benefit of the corporation, shareholders, and or to the extent permitted by state law. So this is a placeholder so that the judges using this will know to check their local state law, and for the benefit of other constituencies. The principal, as we've worked on this, the principal audience for this is going to be not Delaware judges. They don't actually care what we say. If we agree with them, they'll say, that's nice. And if we disagree with them, they'll say, we're Delaware. We don't actually have to listen to you. The principal audience is corporate law, is judges deciding corporate law cases in the other 49 states. Where in some states there are specialty courts, in other states there are not. In no state is there anything close to the amount of precedent that Delaware law has. And for those states, and for those judges, this can be very useful. And so I'm scheduled in October to address the organization of state business law judges to introduce the project to them and get their input. I want to now turn to two sections that I think will be of particular interest here, namely the duty of care and the business judgment. Because this is an area I know is a hot topic here. It's also an area where we had a great deal of conversation among the reporters and with the advisors. At the first advisors meeting when we presented this, the lawyers said you're approaching this entirely the wrong way. Why? They said because you're not talking about 102b7. You're not talking about exculpation.
102b7 זה סעיף של הפטור.
102b7 says that you may amend the certificate of incorporation to include a provision that exculpates directors, not officers, just directors, for monetary liability for non-intentional breaches of the duty of care. Basically. And in any duty of care case, the first question in the United States is, does it fall within the exculpation? And so since it was enacted in 1987, the development of the business judgment rule, which we'll see in 4.02, has been utterly stunted and stilted because the whole issue is 102b7 in the first instance. Now, we're going to restate exculpation because every corporation has it. You can't understand how the duty of care works without it. We just haven't gotten to it yet. So what you have here is 4.01, the statement of the duty of care, which is the standard statement that it's the care that an ordinary prudent person would reasonably be expected to exercise in like position and under similar circumstances. And then in 4.02, you have a statement of the business judgment rule. But what the lawyer said, and they were right, is that this doesn't tell you much of anything without also looking at 102b7. And 102b7 structures things, or maybe distorts things, in a very particular way, because 102b7 means that there's no monetary liability, obviously what is motivating the shareholders often to bring a suit, unless you can show a breach of the duty of loyalty. Now, one effect of that is that things like oversight liability now end up being considered something under the duty of loyalty, not the duty of care, even though conceptually oversight is clearly a matter for the duty of care. Because the standard of violation is that you have to show essentially a breach of the duty of loyalty. So oversight gets tucked into the duty of loyalty because of the standard for the violation. And the duty of care ends up not exactly dying, but becoming very, very tangential. You can still get injunctive relief, but I can't think of the last case where there was an injunctive relief for a breach of the duty of care. So the duty of care is a very odd section here in the restatement. We separated, so the business judgment rule, which of course applies beyond the duty of care, but is importantly in the duty of care, is essentially the business judgment rule as stated in Smith against Van Borkum, as well as in the Principles of Corporate Governance, an attempt to restate that business judgment rule, which itself is a very odd thing to do. Because the business judgment rule announced in Smith against Van Borkum itself was a change from the traditional business judgment rule. The traditional business judgment rule, up until 1985, was much more deferential. Absent fraud or something close to fraud, courts would not intervene in a director decision. Smith against Van Gorkum broke new ground by reinterpreting the business judgment rule to include this process element which we have as 4.02a sub 3. Up until Smith against Van Gorkum, that was not the business judgment rule, but Smith against Van Gorkum was and in retrospect became the canonical statement. The problem, of course, is that Smith against Van Gorkum caused so much of a reaction that within 18 months, the exculpation provision 102b7 was enacted, which essentially reversed most of Smith against Van Gorkum as a practical matter. But since that is the law, and since this is a restatement, we did our best to restate it, and there are some things that will be interesting to hear. One is that a director or officer makes a business judgment. So this does not apply to oversight. This only applies to judgments that are made. Oversight will be a separate section, which will be in Chapter 5. Is not liable to the corporation or its shareholders if the director or officer acts in good faith, is independent. And then 3 is really, for your purposes, maybe the most interesting. Is informed with respect to the subject of the business judgment to the extent that the director or officer reasonably believes is appropriate under the circumstances. So the amount, the process itself, the degree of information is understood in Smith against Van Gorkum, and I think since then, as also subject to the business judgment of the board. How much information they reasonably think we need to have. And then there's this odd 4th category, which was in the Principles of Corporate Governance, a predecessor project which came out in 1992, and has to rationally believe the business judgment is in the best interest of the corporation. This is a residual category that essentially is quite similar to the doctrine of waste. In other words, if there's a decision that is so crazy that you look at it and you say something must have gone wrong here. You suspect that there's self-dealing involved. But you don't have proof that there's self-dealing involved. But the decision is so crazy that nobody acting reasonably could come up with it. That's the category here that allows judges to intervene and refuse to apply the business judgment. So so we now have sort of 2/3 of the duty of loyalty here, with leaving out the most important part, namely 102b7. Let me quickly take you through the duty of loyalty provisions, because they're also very interesting. So we here attempt to describe the duty of loyalty, and then the rest of Chapter 5 are specific examples. So the duty as we describe it is director officer has a duty to act in the good faith belief that such actions are in the best interest of the corporation, and to give precedence to the interest of the corporation over any personal interest. Those are sort of 2 alternative articulations of the duty of loyalty. Note what this includes. This goes beyond conflict of interest transactions. So it includes conflict of interest transactions. We'll see that in 502 and 510. But it goes well beyond that for what you might think of as non-transactional breaches of the duty of loyalty. It also will include the oversight liability. It'll include compensation as a separate section. It includes use of corporate information or corporate property. It includes diversion of corporate opportunity. It includes competition with the corporation. So there's a lot that's going to go on in Chapter 5. We have drafts of some but not all of those sections. So let me quickly look at the 2 sections we have here are 502, interested director and officer transactions, and 510. So this is a restatement of what we take to be the current law with all of its weirdness. And it's important to emphasize the weirdness of it because, you know, this is meant to be, this is really Delaware law, and the weirdness is quite, I think, critical to understanding what goes on. So the key is if there's a transaction in which a director or officer is interested, the director or officer fills the duty of loyalty to the corporation if the transaction is fair, that's the basic entire fairness standard, or after disclosure concerning the conflict of interest and the transaction, which is a source of lots of discussion, what you need to disclose as to the transaction. The transaction is authorized in advance or ratified by disinterested directors. Now, then the third is disinterested shareholder approval. The weirdness here, and I don't see any way around it, the weirdness here is whether the officer director satisfies his or her duty of loyalty may well depend on the actions of other people over whom the officer director has no control, namely the disinterested directors acting in good faith and on reasonable inquiry. So what the Delaware law provides, and what we restate here, is there's an interested director transaction, it's disclosed, and the disinterested shareholders, through sheer laziness, approve it, but not in a way that meets the standard of good faith and unreasonable inquiry. In that circumstance, the disinterested director approval, or the cleansing device, does not satisfy the duty of loyalty, and so in those circumstances, the conflicted fiduciary has to establish the fairness of the transaction. I don't see any way around it because that's the law, but it's very, very odd that the duties are, the fulfillment of the duty of loyalty depends on the performance of other people. Let me just quickly talk about 510, because 510 raises a question that I think you will find interesting. So 510 restates MFW, essentially, and raises what I think of as one of the hottest and most difficult questions. So as 510 is stated, it applies to any transaction that the corporation enters into in which a controller is interested. So that includes going private mergers, where there is the maximum conflict of interest. But it includes also any other interested transaction involving a controller. Now, the case law from the Delaware Chancery Court is pretty clear that unless you satisfy the MFW, we have an abbreviated version of the MFW conditions. Unless you satisfy MFW, then entire fairness is the standard of review in all interested transactions involving controllers. Not just going private transactions, but any other transaction involving controllers. I don't know if this will stay in the restatement because there's right now an open question in Delaware as to the scope of MFW. There's an important article that Leo Strine, the retired Chief Justice, Jack Jacobs, a retired member of the Delaware Supreme Court and of the Delaware Chancery Court, and Larry Hammermash have, that argues that this is what they refer to as MFW creep. That the goal, that MFW really is only appropriate in going private transactions where there's a maximum conflict of interest, and outside of going private transactions, they argue, either disinterested director approval or disinterested shareholder approval should be sufficient to validate the transaction. That question, and of course, because everybody writing that article is involved is an advisor, that question is something that I've had extensive conversations with Leo Strine about, who says, you know, you're restating MFW creep. To which I said to him, well, that's what the cases say. You know, don't, you know, but on the reporters, we had a discussion as to whether to restate the Easy Court case, which is the leading chancery case that summarizes all the cases. And we decided that we needed to do that until and unless the Delaware Supreme Court decides to adopt this argument that Strine, Jacobs, and Hammermash are making, in which case we'll have plenty of time to change it and to restate whatever it is that they come up with. So that's a quick overview of where we are. Let me stop here and turn it over to Justice Rohan. First time I've got to introduce Ruti as a justice. Let me turn that.
רק אני אגיד כמה דברים לפני שרותי